thing to be mentioned, your lordship directed to put the requisite, my lord, for bringing the lower court records, my lord, special messenger. There is a delay of 2 days. Now, my lord, department.
Lordship, may I be allowed to mention a restoration application, Lordship? Most grateful.
Yes.
Madam, may I be permitted to mention a matter? It's for the extension of an interim order. The said interim order is expiring on 31st December.
He said, no, shouldn't. Oh. And this, where is this Bibha
We were far away from the suit property. There is rented hall only for the invitees and the dinner purpose only. 100 years old property. Lord, I shall only fix the pandal and remove it on 17th.
On 17th.
Without any changing nature and character of it.
So weird. That's a sentiment. Such a problem. The appeal is admitted. The appeal is admitted. During the subsistence of an order of status quo, in respect of a nature, character, and position of the suit property, an application was taken up by the appellant to seek permission from the court to erect a pandal over the subject property for the purpose of the marriage ceremony of the daughter, which is scheduled to be held on 15th December 2023. The trial court refused to pass an order solely on the ground that, according to the defendant respondent, there is one marriage hall situated at Sethji Banquet, Maniktola, Kachrapara, where the rituals pertaining to the marriage ceremony can be performed, and therefore the trial court found that it is not a fit case where such permission shall be granted. It is a suit for partition.
Partition.
It is a suit for partition and separation of shares. Which evidently indicate that the appellant has a share in respect of a joint property. the erection of pandal for a limited duration, more particularly for performance of marriage ceremony, in respect of over the ancestral property, has a touch of emotions, sentiments, and the values and culture of the family, and therefore the court ought to have taken a pragmatic approach in this regard. It has been submitted by the counsel for the appellant that after the performance of the marriage ceremony scheduled to be held on 15 December 2023, the temporary structure within bracket pandal shall be removed
Not 7.
within 3 days therefrom,
I'm getting it.
and therefore it cannot tantamount to changing the nature and character or interfering with the possession of the parties. In view of the above, we pass an interim order permitting the appellant to perform to erect the pandal within bracket temporary structure for the purpose of marriage ceremony, and shall remove the same within 3 days from the date of concluding the marriage ceremony. Stop. The appellant shall ensure that no other structure of a permanent nature shall be erected thereon. Full stop. Let the application filed before this court this and this I do not. It is a service returnable on 18th.
Lots of indulgence. May I get a signed copy of the order so that police may not intervene? Why, downloaded copy? Well, I kindly want that, but it will be a downloaded copy will be acted upon by this. Well, otherwise,
Liberty is granted to the advocate and record of the appellant to communicate this order to the trial court, as well as the counsel representing the defendant there, and all parties shall act on the basis thereof.
I'm deeply upset.
Have you invited your co-sharer also?
They are bitter relation, my lord. They will not attend, my lord.
Why?
Though talking terms.
So what? Send them a card also.
They can.
Invite them also.
I'm very much grateful, my lord.
Let's call the list.
Well, I'm appearing on behalf of the applicant.
Police. Yes, sir. What is this
I am
application?
for the respondent. My lord, the
Should
president
they-
filed the application suit for partition.
Oh, this is a mandatory.
Mandatory injunction.
Mandatory.
They
We can make a. I will do it on the weekend. Don't worry. Pretty otherwise. Dictate this. Please do it.
আচ্ছা
এই এটা ডিকটেশনের পর আমার কাছ থেকে জেনে নিয়ে লিস্ট করুন আমার কাছ থেকে জেনে নিয়ে ডিকটেশন হয়ে যাওয়ার পর লিস্ট করুন পাঠিয়ে দিয়েছিল আমাকে পাওয়ার পাঠিয়ে দেবো আজকেই পাঠিয়ে দেবো
The 204, I am for the appellant. This application has been filed by the respondent of praying for dismissal of my appeal on the ground the paper book was not filed. Lord, I filed the paper book that is on record. Lord, I have also given the copy to them. Now, Lord, the matter is ready for
Get
hearing.
the paper book, Lordship, kindly dispose of this application and fixed,
Are you pressing this application now?
if your Lordship allow me to press this
No, I
application.
can tell you one judgment of the Supreme Court also, which says for non-filing of the paper book, appeal cannot be dismissed. If you want, I can give you that judgment. Probably 83 Supreme Court. Read that judgment, originated from the Calcutta. Supreme Court says, no, you can't.
Lordship, kindly dispose it of the application, Lordship, and fix the date for hearing.
So this is, which application? Can?
And 8.
8. Where is the filing number? Give us.
The
There is
paper
order-
book was filed on 7th 8
January
2023.
এই অর্ডার শিটটা কোথায় আছে না না অর্ডার শিটটা কোথায় এটা পেয়েছি Four weeks from the date of service or notice of arrival record. Okay, this is my that lower court record came on the scrutiny. It found that it is not correct. It says defect to the lower court record that defects can be removed immediately. This was done.
But give negative attention to the
Actions, exhibit such and such is prepared, properly signed, whatever is sealed, this is covered. Examined, complete. The notice is served out 4/1/23. This is served on the applicant. This is issued, has been duly issued. This is degree. appeal is now in order, register, issue notice acceptance. Somebody expired. Execution. Considered a so it was extended on 17/4/2023, the period of 2 weeks. When you filed?
But on 7th August 2023, serial number 4.
7th August.
7th August.
So 2 weeks late. Now, while disposing of an application for stay on 21st January 2022, this court directed the appellant to prepare the informer paper book and file the same within 4 weeks from the date of the service of notice of arrival of record. The record reveals that such notice was duly served on the advocate of record on 18/1/2022. Subsequently, the matter appeared before the coordinate bench on 17/4/2023, and on the basis of the submission advanced by the appellant, the time to file paper book was extended for a period of 2 weeks from the said date. The instant application is taken out at the behest of the respondent for dismissal of the appeal, as the appellant failed and neglected to file the paper book within the extended time. At the very outset, we must record that mere non-filing of the paper book should not ordinarily invite the dismissal of an appeal, as the preparation of the paper book under the appellate side rules is for the purpose of convenience of the bench to dispose of the first appeal. Stop. We have been informed that the paper book has been filed on 7th August
2023, and the copy has
2023,
been
VD filing number,
serial number 4, my lord.
document number, serial number 4,
4, only 4.
VD serial number 4 of the event date. Since the paper book has come, has been filed though belatedly, we therefore extend the time to file the paper book. Department is directed to accept the same. In view of the above, the application is disposed of. The application is dismissed. Stop. Since the appeal is otherwise ready for hearing, let the appeal be listed 1 week after the reopening of this court following the Christmas vacation.
But I have given the copy. This is my affidavit of service. Copy of paper book.
Appeal listed. Appeal listed.
Great.
This one should not invite participants.
मला আছে টাইম ওরা কি করে দেখো কালকে চেন ঠিক আছে ফিক্স করে দাও না ঠিক আছে
Yes,
Millard, I'm praying for time accommodation, Millard, because I have taken change yesterday, Millard. This is my predicament.
there is a note, there is a note.
I know that.
So
Yesterday
why you
only,
did not circulate the letter?
yesterday only they approached Millard.
Whatever, why you accepted it? You knew it that this matter is appearing.
that is my,
You should not accept the.
that is difficulty. That is difficulty.
Should not.
That is difficulty. Millard.
I have got a strongest reservation on this change.
Certainly.
So I will not grant adjournment.
There is embarrassing on my part, Millard.
So why you accepted it? It's not an embarrassing. It's an embarrassing
No, Millard.
to us. That's simply because a change has come. So the court has to grant adjournment.
I had to do justice with the client, Millard.
No, definitely
Unless I
not.
get
Then
ready.
you, if you are really thinking of doing
Unless
justice,
I get ready.
then you should get prepared yesterday itself. You
Right.
knew it that the matter is appearing in the.
My lord, that was it.
Why you did not?
That is.
If you like to see the last order, last two consecutive occasion, my lord. Earlier time, Mr. Piyush Chaturvedi, landed senior counsel, appeared, my lord, with Onujit Mukherjee.
Some Mr. Pritish Chandra.
Yes.
Initially,
The order sheet shows that.
but recorded advocate is Onujit Mukherjee and senior appeared, my lord, Piyush Chaturvedi.
No, I do not know.
Whatever is there,
His name
Millard.
is not here.
I shall do that, Millard.
No, you'll have to. Do
I
it.
shall do that.
Do it. What is this application?
This is application for stay of the improving order, Millard. There was suit for partition and declaration, Millard.
Preliminary degree or a final degree?
Preliminary degree, Millard.
So stay application,
My-
usual order for disposal.
Commissioner work has already, what happened, kindly see that decree. But 2019, kindly see when the appeal was filed. Appeal was filed.
Sir, this is the
Fine.
first appeal.
First.
Absolutely. Now, but
The
kindly-
statutory appeal, it is a duty of the first appellate court to hear out. There is no question of any admission
But-
of an
but
appeal. So
absolutely
the
automatic.
order is commission work should continue.
That has
but
already been
the-
completed, Commissioner. May I
The
just,
final degree should not be passed. That's all.
may I just say only two things? May I just say only one thing? Now, the ground of
Your client is present in the court.
only two things. I But what happened, matter, the only ground of challenge is that matter, there is the arbitration clause and why the matter should not be referred to the arbitrator. Now, this is the only ground of challenging the preliminary decree. If you actually see once the grounds, matter, this is the only ground. Now, matter, what happened, matter, this appeal was filed. Thereafter, matter, commission done his commission work upon giving notice. Commission work completed. Report submitted. Then they took time 2 years to file written objection. I came up before this court for early disposal of the passing of the final degree. This honorable court directed to dispose of this final degree application within a certain period of 3 months. That has expired long back. Till today, they have not filed written objection against the commissioner report. This is the sum and substance of the matter. The commissioner report has already been filed.
Get the useful order.
This is the normal.
Yes. You justified your appearance. That's the only ground on
Yes.
which-
Well, at arbiter, there are a lot of things is to be said. Jointly purchased the property, sanction plan were obtained,
You purchased the property.
property, Millard. And sanction was obtained, money was, transaction was there, Millard. Thereafter, these things has been arose due to dispute only. That dispute was amicably resolved with Millard. The dispute can be resolved through arbitration by saying this, Millard, only.
I am admitting his share. Let him take. Let him take. That degree only pass preliminary degree.
There are something, Millard. One mother is there, one tenant is there, one another suit is there.
There is an arbitration agreement.
Arbitration agreement. Not ready, Millard.
That is the only ground, tell us.
Yeah, only ground.
Well, there are something has to be said.
What,
But kindly see, if your lordship take time to Millard, go through the judgment, then everything will be discovered, Millard.
what ground he says that you are assailing the judgment, the preliminary decree?
Arbitration ground is there, arbitration ground is there, Millard.
Agreement.
Arbitration agreement. Millard, I am not.
Answer is very simple. Let us first see.
Things are there.
This point has to be taken first before submission of the.
Ah.
I know it, and I have kept mum for that reason. That
This
let me
argument
first-
has been advanced.
My lord, kindly come to the page 56 of the application, my lord, how the trial court has dealt with this ground,
I'm
arbitration.
asking you, where is an arbitration agreement?
My lord, I have not gone through the everything, my lord, but kindly see the dealing of the trial court.
We are
Till-
fixing on Monday for hearing of the appeal.
That is,
Without paperwork.
that is,
Come, argue. If that is the only point, argue.
then that is not.
Please argue on Monday. Yes, let this matter be listed on Monday as for orders. As for orders in the supplementary list. It is hereby made clear that the parties will argue on the merit of the said appeal. As it is submitted by the learned advocate for the respondent that the only ground alleged against the preliminary decree is the existence of an arbitration agreement.
Civil court is derived from proceedings.
Come Monday.
Yes.
Type it. Correct.
But as per your lordship direction, my lord, the defect has been cured, my lord. My lord, the pottery has been deposited, my lord, on 6/12/2023, my lord. This is the computer receipt, my lord, I am carrying.
Let it go to the staff reporter, give a revised report because it was average. I do not know, you have said why he has said that it is
But this is the filing, my lord, and my lord, your lordship will find the last portion.
you have deposited 20 rupees. Nowadays, how much?
But 100 rupees was asked, my lord, 100 rupees were deposited.
For Bhakanatham,
Yes, my lord.
for Bhakanatham, how
But-
much?
100 rupees we have deposited, my lord. But I don't know what the report was said 100 rupees, so I have deposited 100 rupees.
Does not say it. Bhakanatham contains how many?
20 rupees, my lord, I know, my 20 and my lord, one bar sticker.
How it can be 100 rupees or suit value?
This grant of probate, my lord.
Yes.
This was, my lord, grant of probate, my lord.
So. Repeat the please. Oh, at the time of grants. At the time of.
It was rejected, my lord.
Yes.
But I will be praying for my lord, stay of the order, my lord. My lord, your lordship kindly comes to my lord. This is first time, my lord. I have to serve also, my lord.
Now, sir, because it is probate has been granted.
Probate has been granted, my lord, and he is using that
You are
probate.
an objector.
My lord, my application for probate, my lord, grant of probate.
So it is rejected or granted?
My lord, it is rejected, my lord.
Yes, so.
My lord, rejected.
You are an executor.
No, my lord, the executor, my lord, did not file an application, my lord. So I have applied for letters of application.
Are you a beneficiary or negative?
I am the beneficiary, my lord.
Who was appointed as a
Mr. One Pradeep Kumar Niyogi was appointed, my lord, as a executor, my lord. But my lord, he did not, my lord, file application.
the administration who asked for?
My lord.
The court might have appointed for an interim measure somebody else as an administrator to
My lord.
administer the state.
My lord,
Was it appointed? No. So the state remained in limbo.
my lord.
What are the assets?
But access, my lord, a property, my lord, at Kharagpur, my lord. A premises, my lord, at Kharagpur.
Or commercial?
No, my lord, residence.
Is residing there.
My lord.
Then you serve, come back.
But my lord, they are trying to dispose of the, my lord, kindly consider para 33, my lord. They are showing this probate, my lord, and trying to dispose of that property, my lord.
But also one of the.
But- But my lord, I am not in, I am co-shareholder, but I am not in the position, my lord. But I am only praying for,
Tenable on 18.
I am only praying for stay of that proceeding.
What is stay of the
Stay of that impugned order, my lord.
Can it be? If probate application is dismissed, stay of the order. I never.
But I have to then
No,
come with application for injunction, my
No,
but- thank you.
service,
I'll serve.
returnable on 18. And what do you have taught him?
আমি কি যে
To dismiss a stay of the judgment. Just imagine.
First, my lord, file as an injunction, my lord, but the mistake was done in the prayer. Perfect, but
Yeah. Next.
Lord, your lordship was pleased to make please, your lord.
Matter Millard, I appear for the police important dispute of the property defendant.
It take two. No, the main mischief one will be oversun presence. Lordship sees my lord's second page of my lord's order. The answering defendant is not here.
He has said that cannot be used as a burial ground.
Yes. Ah,
The other side, service.
but service is there before your lordship. Lord, everybody has
Well,
been served,
defendants are not here to answer.
but the principal defendants are not here before your lordship.
Why? Why they cannot be served?
Lord, they were served. Served.
Just for defendant.
Yes. Everybody's been served.
The door lock.
And they have appeared, my lord, before the trial court now. So if your lordship so wishes,
Did you serve or
notice on the lawyer. On the lawyer. But if your lordship sees, my lord, the affidavit of service, they've received it.
which one? You have
My lord, they've received it. They kindly looks to, my lord. 8. To addressee. Delivered to addressee. Till 6 weeks, my lord, from the day your lordship was pleased to pass the order. 10 weeks. 10 weeks. Yes, 10 weeks, 3 months. Well, it is still there. Yes, that's there. I may serve upon, my lord, the lawyer appearing in the court below, my lord, and come back just after the
The
vacation.
affidavit of service by today reveals that the
Harish,
service. is affected. Of them. There is no appearance by that. The police administration is represented
as well as corporation is also there.
as well as the because of as they directed earlier, because of the nature of the involved in the suit. Since the principal defendants are required to be present in the instant matter, since the appearance of the principal defendant necessary, We give another opportunity to respondents to appear in the matter. We are informed by the council for the that the respondents have entered appearance in the entered appearance in the through a council to stop. In view of the above, directed to serve on the council. The council. 19th December.
Look, maybe on 18th December.
Yeah, fixed 2-3 big matters.
17th.
Can come, yes.
No. 17th. 15th.
17th come.
15th, Millard. That's why I was very surprised that your Lordship Millard was so eager, Millard, to grant, which is surprising. So that's why I thought, Millard, there's something wrong somewhere.
Come on, 19th.
19th.
Is there any difficulty 19th?
Yes,
What?
Millard. I usually don't say about any difficulties, Millard. But 19th and 20th, Millard, I have, Millard, in there is a outstation, Millard. Great, Millard.
Give your memo of appearance.
That they will definitely.
This matter, I am appealing. As per your lordship direction, I have copy to the respondent.
Why you are appearing in the respondent side?
Sorry. Sorry. But I have served, but the postal report is addressee cannot be located. Thereafter, I have served to the learned advocate who is appearing in execution case. I fear not today for that reason.
Want to serve?
Yes, I have already served.
The advocate
Yes, I have sent. So send to the learned advocate.
does not come.
No, no, Millard. No, Millard.
Go and do it by hand. Advocate is always available.
I fear only not today.
By post.
I fear only not today. Grateful.
I am the applicant, my lord. The
I'm for the respondent, my lord, Mr. Banerjee is leading me.
appeal was admitted with the direction to deposit the digital amount, but the amount was not available as such. Now the amount has been available. So I am praying for time, extension of time and leave to deposit the digital amount. 93 lakhs 93 lakhs 19,606, page 4. অসাধারণ দুটো আছে
Done.
Yes, ma'am.
My brother's copy has a different document. My copy has a different document. Which one is?
This is my copy.
This is our copy. We are giving. Your copy, this is our copy. Look at it. Both can too. Look at it. So, document the copy.
Not today, I will file another.
What not today? Look at it. What you have done. The letter of another case has been included in my copy, and the letter of this case is included in his copy. Totally different. Look at it, the amount. Both the letters, same day. One is 75 lakhs and odd, one is 93. Which one is correct? We don't know.
93.
So what you have done to my copy? Original copy?
My lord, not today, I will supply tomorrow.
This is what how the state conducts the cases.
Yes, yes, my lord, my fault, my lord. It is my fault.
We are going to reject this application on that ground.
No, my lord, I am.
With cost. With cost. What?
It is my fault, my lord.
So you pay the cost.
No, my lord, I have no such money.
Don't have. When you raise the bill, you don't have. It was granted to the applicant to file a supplementary affidavit. The copy of the letter dated 7/2023 issued by the Assistant Secretary to the Government of West Bengal.
8 of 2000. 8 of 2016. By Tuesday. This is the matter on the better.
10 and 11, madam. 10 and 11. এইটাতে জানাচ্ছে ক্লার্ক করেছে ওইটাতে 11টাও সেম
Let him check whether in 11 also there are similar mistake. Otherwise, this order
Has to be. Because reverse here case number 8 is this. My brother's copy has that document, but my copy is miscellaneous case number 10.
10 ওইটা উল্টো
copies have been swapped.
And there also the same thing will happen. File it in both.
deeply online.
Yes.
Your Lordship, in item number 212, Your Lordship, there was a previous direction by Your Lordships to serve upon the appellant, to respondents, Your Lordship. We have served, Your Lordship, but the service is incomplete, Your Lordship. I am praying for a week's accommodation so that we can come. As Your Lordship.
Let this matter appear after. Because others wanted to not shine.
And for the respondent, my Lord, I humbly pray for it. Lord, I humbly pray for an adjournment on the personal. And for the respondent, I pray for an adjournment on the personal ground of my senior, Mr. Vikram Banerjee.
On 1st December, when this matter was taken up, 1st December, when this matter was taken up, same accommodation was sought. If that being, we granted the accommodation because you were in difficulty. The order speaks of
My Lord,
on
kindly,
the
my,
prayer of the respondent, let this matter be listed in the next that you asked for.
kindly, my Lord,
No, sir.
my Lord.
There must be something. This menace of adjournments, we will not.
Lord.
No. He knew it that the matter has been adjourned at his behest or at his instance.
Lord. It is not that, my lord, he was here the whole week, my lord, but he could not be present today due to some, my lord, he's not well, that is why.
What?
He's my senior is not well, that is why he could not be present.
Who
in
is your
court
senior?
today. Mr. Vikram Banerjee.
Where is he? Vikram Banerjee?
He's not in court, my lord. He's not in court. He's not well, that is why he could not come to court today, my lord.
Have you paid this 50,000 rupees?
Yes, my lord, I have paid.
Yes.
On the last occasion, it has not been reflected in the order, but I have paid. Yes, my lord.
Because the adjournment is sought, what can be recorded?
I apologize, my lord. But yeah.
Summon Monday? Do it? Monday? Not today only?
Good. Grateful. My lord.
Your Lordship, I'm on behalf of the appellant's advocate. He is in another court, so I beg for a passover and kindly fix it at 2 p.m.
So actually, he runs the court as and when he feel at what time he will come and argue, the court has to.
Actually, he is having he's on a hearing in another court.
So what? So why to say 2 p.m., 3 p.m., 4 p.m.? Why?
It's not that, actually, it's the seniors.
So let him. He will dictate us how to, at what time his matter should be taken up.
It's
Must have taken the services of the astrologers.
yes.
Tell him to come at 12:15. It will be called on at 12:15. If he does not appear, we'll dismiss the matter. Tell him.
A pleasure.
My lord, in this matter, my lord, deficit court fees have been put in. Deficit court fees. Yes. What is the application, sir?
Application for injunction in connection with the partition
Fruit. Preliminary decree or final decree?
preliminary decree.
Preliminary.
That there had been injunction in the there had been injunction before the court below, which was assailed by the defendant by filing miscellaneous appeal. That was confirmed. Injunction order was confirmed. Subsequently, suit dismissed, and we have
On what ground?
dismissed on the ground, my lord. Actually, my lord, my client.
Non-implement of the co-sharer.
No.
Defect of bad for partial partition or what?
No, what happened, my lord? My client's predecessor took the property by way of exchange from the defendant's predecessor. Defendant, my lord, had one uncle. The uncle transferred some property which was not partitioned, and there had been an indemnity bond that in case my property is disputed, I have got some separate property. You can get your share from my separate property, which are not undivided. Ultimately, the defendants took away some of the properties which were given to us in exchange. And thereafter we filed that, previously they filed partition suits, thereafter they withdrawn, and subsequently we filed the partition suit. And the my lord, trial court held that our suit is not maintainable. That's why it has been dismissed, that has been challenged, my lord.
Now,
Here.
what is the nature of injunction you are asking? for?
Injunction, my lord, I am in possession of the property. Not to change the nature and character and possession of the suit property.
Was there any deed of exchange or something of that kind?
Yes, my lord, that has been annexed, my lord. Deed of exchange. Page, huh? Page 19 onwards. And relevant portion is page 22.
So what injunction?
An injunction, my lord, not to disturb my possession.
But there is a categorical finding of the trial court that you are not in possession.
Lord, is
are not in possession of the suit. The basis of the indemnity cannot take. But they are not in possession, so we can't. Like we accept it.
the judgment of the
Page 8. Page 8.
yes.
Line about 1, 2, 3, 4, 5 from the bottom.
The plaintiffs fail to prove how the acts of defendant are creating disturbance in. No, the plaintiffs.
No, that second, next sentence.
Yes. The plaintiff are not in possession of property and on the basis of indemnity clause. They cannot claim that. There is nothing on the evidence of the plaintiff. They given status quo order. There is nothing on the evidence to the plaintiff which goes to show that due to the acts of defendant.
Sir, if the court finally concludes that you are not in possession, that shows that we can't grant you an injunction in that form. Unless you show by a very convincing material from the record that you are in possession. No presumption.
I would kindly see.
Conclusive evidence that you are in possession. Not on the basis of presumption. Record of right. We don't want to go into that.
Kindly see page 47, page 47 of the application.
Sir, the parties have adduced evidence, sir.
I
visualize this situation.
That is also subject matter of challenge before the applicant.
Sorry?
If that I take as my lord granted, then I have no appeal. I cannot.
Are you not realizing that what is playing in the bench's mind? Sir, you are taking us to a finding returned by the court on an application for temporary injunction. Maybe an appellate court, this high court has at that time observed something.
Yes.
That was a prima facie finding based on other materials. But the moment the parties went in trial, and therefore in the trial it is held by the trial court or found that you are not in possession. These findings will not.
My lord, this yeah, I do admit your lordship view. But
no, this is a law, not a view.
No, my lord. At the same time, my lord, I have challenged the degree.
True, that's why
I have challenged the
you have not understood what we say.
Yes.
You have challenged the decree. There is a conclusive finding returned by the
So
trial court. Now, unless you show
with the very convincing material that you are in possession, we will not go and pass an order of injunction in that form. We have means you can show us from the evidence of the other side that look, he himself has said that I am in possession. I can understand. It's one of the best case where the court will grant you an injunction.
My lord, your lordship is perfectly right, my lord.
You want
My lord,
that.
my lord, that's why I'm praying in a modified form. Let it be an order of status quo, not to change the nature character.
Where is the judgment of Kishore Khaitan's case? 2006, volume 4 SCC. I think the answer is given by a Supreme Court in that judgment. Yes. Status quo, when there is a serious dispute relating to the position of the parties in respect.
No, my lord, at the same time, the ownership, the proprietary right are all.
Where is that judgment? Kishore Khaitan's case? 2006, volume 2 of 4 SSC.
Huh? Huh? My lord, your lordship, my lord, save both the parties. Save both the, because if the property is sold,
Ready, we are ready, but
property is sold, transferred, then it will be infructuous.
What prayer you have made?
Your lordship can, my lord, mold the prayer according to
at the time of an admission. Tell me.
My lord, kindly see what is the prayer, my lord. Not to pass an order in directing dependent, particularly dependent on 11 to 14 form, changing nature and possession of the property. Nature, if he is possession, if he is possession, nature and possession of the property till disposal of the appeal. Further directing the defendant to demolish the unauthorized which have been made, it may not be, during the pendence of the suit in violation of the interim order, and to pass and such.
Got that Kishore Khaitan case?
I have not got.
Got. It was from Calcutta High Court. Sorry, we can't pass the order. Are you appearing?
My lord, I beg your pardon to enter in the middle of the proceeding, my lord. Am I audible? I beg your pardon to enter in the middle of the proceeding, my lord. I am for the respondent number 10 to 18 and led by Mr. Zubair Ahmed. I just get information from him a minute ago that he is not, he is ill today. So that
Do
he
one
can't
thing, we are
come
not
today.
going to pass any order at this stage, but file your affidavits so that we can decide this.
In the last occasion also, time
Yes,
was.
at that time we didn't have the proper instruction, but we get that the instruction from our client.
Now, after hearing that, we find that the interim order of such nature cannot be granted at this stage. So we are permitting you to file your opposition.
Let them file of minimum minor protection, not to my lord. If we have to sell transfer around, at least sell transfer.
But you have not asked for.
My lord, your lordship, nature, character, position.
Are you aware of the latest Supreme Court judgment in 2021, which says that the court shall not mold the relief at the initial stage of granting the interim order? It is only when certain period of passage of time has elapsed, some changes has come, then the court may definitely mold the relief, not at the initial stage. The Supreme Court deprecated that.
No, they are restrained from raising construction, and my lord, that will be completed.
But you have not prayed for. You have simply said that
nature character may includes nature character includes my lord that thing, my lord. If nature and character did not change, that will include some protection, minimum protection, my lord. Kindly, partition should, my lord, some protection. They are taking out not the money, not the interest.
Or we can forgo this conversation.
Opposition before vacation,
Okay, well,
reply 1 week after vacation.
Well, some protection may be granted. Well, first appeal, my lord, I can assail the, my lord, factual aspects also. Well, observation is subject to,
Show us from the evidence that they have admitted that you are in
no,
possession.
they may not
Again-
admit, my lord.
Again, I'm saying, if the conclusive opinion has been given by the court that you are not in possession, then what remained?
No, my lord, let
You
him,
can't
let him retain the possession, no, he not transfer the same to somebody.
Where is the case made out for transfer? There must be something that he is bringing the several persons, he is showing that property, he is trying to sell out. Something is there, some materials,
Definitely,
some.
well, I'm.
You have lot of experience of the trial court. You know that what documents are
My lord,
required.
My lord, kindly see, my lord, I have stated that some constructions has been made.
Construction does not mean.
Yes.
It's a question of alienation.
Well, there the court felt that there is an, my lord, necessity of injunction. That's why both the courts, my lord, trial court as well as the.
But at that point of time,
My lord, that is there, my lord.
at that point of time, the evidence did not come. The court was of the view, prima facie, I find that you are in possession. And thereafter protected your position.
Yes.
But at the after the evidence and the trial, now this has come. He says that you are not in possession.
All right, he may be in possession, my lord. Partition should he sold.
But something is to be made out. File unnecessarily should not come 1 week after vacation. Application.
My lord, I have stated in the petition that
you file it.
My lord, paragraph 5.
We are not going. Yes, call the next matter. No.
I have stated that we are in absolute physical possession thereto for more than 12 years.
Them. This is contrary. The finding of the court is sacrosanct unless upset or disturbed by the appellate court. Even if you shout that I am in possession, if the court has recorded you are not in possession, that is sacrosanct.
That is
A.R. Tule's judgment read.
My lord, first appeal. No.
AIR 1982 Supreme Court, page 14.
If it would have been
What is
second
this
appeal,
judgment?
second appeal, my lord, your lordship would shut my mouth. But here it is a first appeal. All question of fact and law.
We cannot shut the mouth of the member of the bar under any circumstances, sir. They are very vocal. So we always accept and we invite gracefully that they should open, because it is, after all, in pursuit of the justice.
Definitely.
But we never say so that we shut. We never shut. If it is a first appeal, that does not mean that the court will simply on a drop of the hat will grant a stay. No.
No, I am not saying so. I am not
That is
saying
what is, because the court, the language under Order 41 Rule 5 also says that the court will take into consideration certain aspects. And then the court may pass an order as it deemed fit by putting some conditions, some restrictions. It is the case of an injunction where you have to make out. The pleading has a very important role in the dispensation of justice. Something which is not pleaded, something which is said at the bar, oral.
No, not.
Will the court go on the basis of that?
Should not be. I am not
Something
saying.
has to be brought on record. So let them file opposition. You file your reply. Whatever you want to say, say. We'll consider the application. No difficulty. Yes, call the next matter.
117, my lord, I wish to appear on behalf of the appellant. The last occasion, your lordship directed me to file a supplementary affidavit. So, I'm appearing on behalf of the appellant wife, my lord. On the last occasion, your lordship directed me to file a
Pick up the
supplementary.
details
Yes, my lord.
of the expenditures.
Of the expenditures, my lord. I have of the daughter's educational expenses, my lord, I have given.
It is all in a habit. Index is not introduced. Index is not introduced. Look at the index, what they do. Synopsis. Synopsis, nothing that you normally pass the preliminary. The synopsis. Synopsis. These are the what? Partition suit file, statement, examine, the judgment. Yeah. No index editions. Yes, sorry.
Lordship, I beg to appear on behalf of the appellant
Why you beg?
before your Lordship.
Why you beg? You have a right to the begging may invite refusal also. Can we refuse you that you can't appear? So we cannot refuse you from appearing for the appellant, then why begging? Straight away, these colonial expressions at that point of time were there. Here, you should say, I'm for the appellant. You have a right to represent the appellant. Why beg? Those old colonial expressions you are using again. Yes, anyhow, sorry.
Lordship, I apologize for the wrong valuation statement in the first title of the memorandum.
What is the value? Nil.
It is no Lordship. Memorandum Lordship. It is 30 lakh instead
No,
of
no, in application also you have said nil. Look at the application which you have filed, application valued at nil.
I apologize. I'm paying leave to
It is a 30,000.
30 lakh Lordship. That will be 30 lakhs.
Where is the decree of the title? Yes, 30. Yes. Yes, correct. What is this application?
Lordship, I have prayed for stay of operation of preliminary decree, Lordship. Lordship, actually, a scheduled property.
Have you served the copy?
No, Lordship, there is no.
Serve the copy and come back.
Lordship.
When? How soon you can serve?
Within 1 week.
Where is the property?
At
Which court? Sorry.
Paschim Medinipur district.
Can you serve it within a week?
Lordship.
Can't serve it within a week.
My house is there, Lordship.
Oh.
Leave is granted to the advocate and record of the appellant to correct the valuation statement, both in the memorandum of appeal as well as an application being CM 1 of 2023, here and now. The appellant is directed to serve the copy of this application upon the respondents by speed post, as well as the learned advocate representing the respondent in the trial court by hand, and shall file the affidavit of service on the returnable date. Let this matter be listed on 19th. DP of
20 Mlad, I am for the appellant, Section 5 Application Limitation Act. I have not served, Lordship, direct.
1 week after vacation. The appellant is directed to serve the copy of an application for condonation of delay upon the respondents by speed post and shall file the affidavit of service on the returnable date. The application is made returnable 1 week after the reopening of this court following Christmas vacation. Eta likhe rakho.
Great.
My lord, I am for the appellant, my lord. Let my senior partner to what my lord. There have been, my lord. There have been another application, my lord, which has been hard on, my lord, 1st December of 2023. That by said application, my lord, the applicant challenging the, my lord, final orders of first additional
Section 5 has been allowed.
No, my lord. In this application,
Lordship, I want to file an objection, Lordship. Lordship, delay
How
of
many
5
days?
years, Lordship. 3 months, 25 days.
Delay of
5 years, 3 months, 25 days. And I am appearing on behalf of only respondent number 4.
you have served upon all.
my lord, my lord, my lord.
Only respondent number 4 is appearing.
My lord, in this application, only my lord, respondent number, my lord, here is the appearing, and my lord, the respondent number 1, 2, and 3, my lord, they are, my lord, appellant in FAT number 334 of 2023.
Lordship, in one of the appeal challenging the final decree, this appellant along with the other respondents have filed a single appeal. And here, Lordship, they are made Lordship respondent.
My lord, we will file the transportation
You are
application.
appellant there along with him.
No. I am the respondent in both of these appeals.
So why don't you serve them also?
My lord, I will serve, my
The respondent number 4 has appeared in the instant appeal and prays for direction to file affidavit in opposition to an application for condonation of delay. The other respondents have not been served. Though the learned though the learned advocate appearing for the respondent number 4 submits that the aforesaid respondents have joined with the appellant in an appeal filed against the final decree. Which is pending before this court. In view of the aforesaid fact, the appellant is directed to serve the copy of the instant application for condonation upon the other respondents, either by speed post or by hand, as the case may be. Stop.
The respondents are directed to file affidavit in opposition to an application for condonation of litigation within
2 weeks.
2 weeks from date. Reply, if any, shall be filed on a reopening of this court.
Lordship, let both the appeals appear together. I'm supplying the number of the other appeal, Lordship.
Let this shall be filed within a week after the reopening of this court following the Christmas vacation. The application is returnable 1 week after the Christmas vacation. Since the other appeal is filed assailing the final decree passed in the said suit, let the instant appeal be heard along with
FAT 334 of 2023.
334 of 2023.
Great.
Yes.
Yes, ma'am. I'm for the producer. The plaintiff's appellants is a petitioner suit for partition in respect of their 1/3 share. Some of the defendants appeared and they contested. Yes, service. Those who are contested, all are delivered. And
All
also
are delivered. What? Where delivered?
no, not delivered. Track report from find that the all are contested defendant, my lord, they are appeared and contested the suit in the court below.
Yes.
They appeared, my lord, in the from
Okay,
track
appear
report, your
means
lordship
appear before whom?
appeared in the court below.
So what? The
Service delivered. Upon
Delivered.
delivered. Effective service, my lord. I'm saying that effective service.
effective service.
Now, my lord, the suit was dismissed only as the plaintiff did not bring all the suit plots in the suit. One to 29.
The name of two of the name of appellant number 6 and respondent number 15 do not tally with that of the impugned decree. Why?
No, my lord, your lordship, that's why. My lord, your lordship, kindly page 2. Page 2, certified copy, my lord. Page 2.
Of
The name of
decree or judgment
degree, I'm sorry, degree
of the trial court.
Yes. 14, name for Shantana Das, wife of Kailash Das.
Just wait.
And my lord, I'm sorry. Degree in page 2.
Page 2.
14,
Legal heirs of whom?
14 Shantana Das.
14
Shantana Das, wife of Kailash Das.
Shantana Das, wife
Yes.
of Kailash Das.
Kailash Das, my lord, and thereafter 15 Shantana Das, wife of Monglu Das.
Shantana Das, wife of Kailash Das.
Yes.
The name?
Thereafter
Respondent number 15.
15 Shantana
Who is
Das, wife
who
of
is the
Monglu Das.
15 here? Who is the respondent number 15 here, madam?
Yes, I'm telling you, lordship.
15 is Srimati Mantana Das.
Elias Shantana Das. Elias Shantana Das.
But she's the wife of Manglu Das.
Yes.
But she's the wife of Kailash Das.
It's another name, 14 Kailash Das. And this, my lord, wife of Monglu Das. 14 is Shantana, wife of Kailash. And 15 Mantana, Elias Shantana, wife of Monglu Das. Two are different. Not same.
14. Oh. Yes.
Yes, well, a suit was
And what about appellant number 6? Purno Das.
6.
Purno Das. Appellant number 6.
Appellant number 6, well, Purno Das. Yes.
Yes, Purno Das.
Yes. Wife of Mahendra Sharma.
Okay, the name does not tally. She is a plaintiff or what?
Plaintiff, yes, plaintiff, well, plaintiff. Wife of Mahendra Sharma.
Yes, Purna Das. Yes. Does not tally. It's tally. She is the respondent number 6 there. Sorry, plaintiff number 6. Mahendra Sharma. Then why is it that- Mahendra Sharma. See, Mahendra Sharma.
এটা তো জানি না 6 নম্বর কেন
Noted the report of the additional stamp reporter put on the reverse of the first page of the memorandum of system. It is pointed out that the name of the applicant number 6 and the respondent number 15 do not tally with that of the certified copy of the income decree. After making a comparison, we do not find that there is any discrepancy in this regard, and therefore the report has been erroneously.
নাম দিয়ে দিই
The additional stamp reporter shall make a revised report. What is this application?
well, application for injunction. Well, initially your lordship passed an order, the status quo and not to change the nature and character. Now, well, the suit for partition in respect of their 1/3 share. And the suit was ultimately dismissed as the plaintiffs did not bring all the suit plots in respect of their share. As such, the partial partition is not maintainable. Your lordship, kindly see the ordering portion issue. Your lordship, kindly see the plaint. I have annexed my injunction. I have annexed my injunction application. Kindly see the plaint, page 21. Scheduler order there. Now, kindly come to page, my lord, order. Issue number 527. Your lordship, kindly see the page 6 of the judgment. Issue number 527. Last thing, last order portion. According to the evidence of DW1 and DW2 and Exhibit A to Exhibit A. Issue number 527. Last, my lord, according to the evidence, middle portion. According to the evidence of DW1 and DW2 and Exhibit A.
Middle portion. Oh, yes. According to Exhibit 1.
According to the evidence of, yes.
Exhibit 1 or what?
According to the evidence of DW1.
Yes.
DW1 and DW2 and Exhibit A to Exhibit F. I find the Exhibit F, that is the attested copy of the arrest record of rights being Khotian number such and such, Bimal Das Rakhalda, in respect of but the suit plots 1371, 1372, 1310, which are under Mauja Harish Chandrapur, documentary evidence Exhibit 1, that is attested copy was not there. I find that the plaintiffs did not bring all the suit plots owned by the plaintiffs and defendants. As such, part partition is not maintainable. Now, your lordship, kindly come to page 21, top shield, the schedule of the property. All are there. All has been mentioned, my lord. 1371, 1372, 1310, 1876, and 1943. But it's covered by your lordship's judgment, unreported judgment. I believe. And by your lordship's unreported judgment, madam. হ্যাঁ আছে এই ছেড়ে দিন ওটা দিয়ে দিন বলতে দেবো ওর দেবেন না ছেড়ে দিন এটা আমারটা বেটার কেস আমারটা বেটার কেস অ্যামেন্ড করতে বলে দিন
What he wanted to say that 950 was not included. Lot number 950. Sunil equally 3%. Agents are the heirs of Sushil. Dependents. Here, dependents also. The pay for one-third share of respect of the कभी आरिस करते हैं 329 officers inside, but which starts of anything. Figure of how Sushi. According to Exhibit 1 means career. The suit property so keeping the same repetition equal. So one third. The printing of the so one third. The defendant. The defendant also educated that's what we according to evidence of data exhibit 8 is exhibited attested for the arts record for Khatia number 2 is different. River of Makha, human, so she can see. But the student lot number such as which are under media, the attested copy of 6 itself. The 950. Yes, madam, 950 has been omitted.
Yes, my lord, then your lordship, your lordship judgment is covered.
What covered?
I have right to amend the claim. The unreported judgment. That ground, my lord, the partition, it's not suit, it's not maintained.
No, that we can grant, that we will set aside and permitting you to amend the plan
Yes,
and
yes,
then
yes,
go
yes.
back.
Yes,
No
yes,
problem.
yes.
But this stage has not reached.
It's all right.
Because after all, the partition suit has taken or consumed so much of time. So that is what we say, that you should be given an opportunity to amend.
Yes, yes.
And include 950 or 50 also as a. But not at this stage.
Then informal paper book, my lord, your lordship kindly granted, my lord, short.
Other side has not come. If they appear, then we can dispense with the notice of appeal. Otherwise, we have to direct that the requisites to be filed for effecting service upon them.
Well, then your lordship directed to serve, my lord, upon the learned advocate in the court below.
What court below? Your suit is dismissed. What court below?
I have served notice and copy of the.
Sorry? Your suit is dismissed for partial partition. So what remains?
Notice of appeal. Yes.
So there is no trial court now.
No.
So what to do? Tell us.
As your lordship pleases, my lord. And dispose of the application and your lordship directed to expeditious the paper book and done such a motion. কি করবো আমি কি করবো আর interim order granted till the disposal of the appeal. হ্যাঁ ট্রায়াল কোর্টে অ্যাপিয়ার করেছে ওরা some of the defendants. তাই না?
Despite service, there is no representation on behalf of the respondents. Let the affidavit of service filed today be kept up. The instant appeal arises from a judgment and decree passed by the trial court, by which suit for partition was dismissed solely on the ground of partial partitions. According to the learned judge in the trial court, all the properties belonging to the parties jointly have not been included in the said suit, and therefore the plaintiff appellant is not entitled to partition of the other properties. At the time of taking up the instant application, we find that the plaintiff appellant was enjoying the order of injunction during the currency of the suit. And because of the dismissal of the suit on the technical ground, the said order of temporary injunction stood vacated, having merged into it. Taking into account that the order of temporary injunction was subsisting for a considerable period when the suit was pending before the trial court, we reimposed the said order of temporary injunction to operate for a limited period. Since the respondents have not appeared, nor we had an opportunity, nor we have an opportunity to ascertain the ground of defense. We proceeded on the basis of the averments made in the instant application. Stop. It has been averred in this instant application that taking advantage of the dismissal, the respondents are making construction of the suit property and also trying to disturb the position of the plaintiff respondent, as well as the other questions. Since the appeal is filed under Section 96 of the Code of Civil Procedure, which is required to be heard by the first appellate court, we feel that any dissipation of the property during the pendency of the appeal may cause irreparable and immense injury to the appellants. We therefore confirm the order of injunction passed on 19/10/2023 to operate in the disposal of the appeal. The application being Can 1 of 2023 is accordingly disposed of. Write an order in FA 346. The appellant is directed to put in the requisites for effecting service of notice of appeal upon the respondents, together with the postal cost, the address, you just get it there, within a week from date. After the filing of the requisites, within the time stipulated herein, indicated herein in above, the office shall ensure that the service is effected immediately. Let the lower court record be called for through special messenger at the cost of the appellant. Such cost shall be put in within week from date. Within 5 days from date. Yes? Within a week from date. Upon deposit of the special messenger costs, the official shall take all possible steps to bring it to this court within 1 month therefrom. After the arrival of the lower court record, the official examine the same, if found complete, shall serve a notice upon the advocate and record of the appellant under Chapter 9, under Rule 12 of Chapter 9 of the Appellate Side Rules. Next, the appellant is directed to prepare 8 copies of informal paper book, typed, written, cyclotyped, printed, within 4 weeks from the date of the service of notice of arrival and record. On service of notice of appeal having effected upon the respondents and the filing of the paper book within the time indicated herein above, liberty is granted to the parties to pray for early listing of the said appeal.
এই দিয়ে দিয়েছে না হ্যাঁ বলছি দাঁড়া
My lord, in item 223, Mr. Chittopriya Ghosh is the advocate on record. Due to some medical emergency happening to his wife, he could not be able to come to court today. I'm praying for not today, honestly.
Next item.
I am in 223.
Not today.
No, I appeal for the appellant. And after admission of the appeal, your lordships please are to
Admission
direct
of first appeal.
FMAT against the your lordship admitted.
Service
has been sent. My lord, in the meantime, my lord, one mistake we have committed. Rather, it is not we are not aware of this. The pro forma defendant there in the suit, who was the initial owner, sold the property to the so-called plaintiff there, expired during the pendency of that suit.
Then what to do?
Order 22 rule for application was carried. Application allowed, substituted. But in the amended plan, we did not get that amended plan. As such, we made the cause title keeping that dead person is the pro forma defendant.
You have to take steps.
Yes, I have made an application before your lordship will say itself. That is the can 2.
Where is the judgment of the Supreme Court? Where is that judgment? 2000 volume 9.
Volume 9 SCC.
SCC.
Yes, I got, but I know your lordship.
So why you have?
Sorry, it is it is my fault.
No?
In spite of knowing that, I could not. It is my fault, my lord. কি আছে তুমি আছো নাকি না হবে না হ্যাঁ রেজিস্ট্রেশন হয়ে গেছে দাঁড়াও দাঁড়াও আমরা So
service
that should be expunged and surface service.
Can't be expunged.
It is there.
Can't be expunged. What about the left out parties then?
No, it should be.
So take out the proper application.
Yes, I have made that application.
Have you sought for an addition of the left out?
Yes. Can 2. I have paid to add them as party. Legal heirs. Prayer is there. That is why I am praying.
Hey, tell your clerk to re-stitch this can 1.
Stitch করে দাও এটা খুলে গেছে করে দিচ্ছি can 2 is there
একদম পুরো বেরিয়ে গেছে
Before rising, my lord, I am saying one.
We are going to dictate the order.
I think, my lord, your lordship.
আমি বললাম তো আমি স্টিচ করে দেব
Extremely sorry, my lord.
আরে ঠিক আছে
The instant application is taken out by the appellant seeking expunction of the name of the pro forma respondent number 1 and addition of the parties in the instant appeal.
Page 10 and 11.
It is stated in the instant application that the sixth pro forma respondent number 1, who was also arraigned as pro forma defendant number 1 in the suit, died during the pendency of the suit, and on an application under Order 22, Rule 4 of the Code of Civil Procedure, the heirs and legal representative of the said deceased was duly substituted.
Yes.
However, at the time of preparation of the memorandum of appeal, the cost title was prepared on the basis of unamended plaint, and therefore due to bona fide oversight, the deceased pro forma respondent number 1 was inadvertently impleaded as party in the incident. Since the said deceased left behind him surviving the heirs and legal representatives who were already substituted in the said suit, such mistake appears to be bona fide, and we thus do not find any impediment in expunging/deleting the name of the pro forma respondent number 1 and adding the heirs and legal representatives as shown in the prayer portion.
Yet,
as pro forma respondent number 1 series.
1A and 1B is there.
That is a series. Stop. Accordingly, the application is allowed.
Yet,
the office shall carry out the necessary amendments in the memorandum of appeal.
May I serve after
service of can 1?
Can 1 and can, yes, can 1, yes, can 1. Oh,
service of can 1
upon the added respondent.
Upon the added respondent, pro forma respondents.
Added pro forma. Yet, much obliged.
My lord, item number 225, I am the appellant, one of the respondents. My lord, you love to kindly give me some after vacation.
Lordship, I appear on behalf of the respondent number 1 and 2.
1 has died, so substitution has to be taken, has to be carried out.
I think that was the submissions on the previous occasion also.
They have not. So limitation will intervene. The abatement may be there.
That partition should rely.
My lord, I think
After preliminary degree died or before preliminary degree?
Extension
partition is not maintainable. Yes. It is the decision taken by the.
That's on a merit.
Can it be returned?
No, we are continuing because
my lord, only one.
mandate is to rise at 2. So we will continue to take.
Only one indulgence.
So we'll rise at 2.
228 should not come under the heading application. That's I just want to mention, my lord. It should come under the heading extension of interim order. So 228, let it be.
228. What is the resolution? Will you come at 2?
No. The resolution has been taken from 2. We shall.
So can we continue till 2?
Lordship can.
But 225 after vacation.
So let us call.
25 after vacation, my lord.
Yes.
Up to 25 after vacation.
Let us call. Continue.
Can it be returnable, that method after?
Which one?
The 224. It also can fix any date after 3 weeks or 4 weeks returnable after service.
1 week after.
On
reopening of this court.
Yes.
Yes, call the next 225. Yes, you want 225.
I am very sorry, my lord, because we have taken a resolution. But before that, my lord, I have mentioned. So I am apologizing, my lord. Your lordship kindly adjourn the matter after vacation.
225. You have to take steps.
Okay.
And on the prayer of the appellant, let this matter be listed up 1 week after the reopening of this court following the Christmas vacation.
Get to
Lordship would record that.
I am very sorry.
Is a single word or 2 words? Yes. What do you say? A single word or 2 words?
I can say it.
Your next, my lord would be kind enough to record that they want to prefer an application to that extent. I'm grateful. No, I get it. No, I understand. I'm grateful, man. It will slip in that.
Yes, next 226. For the respondent. It's for the appellant.
Thank you.
7. The applicant side.
It's the application for restoration. Yes, as per order passed there. They have received, restoration along with an application under section 5, the limitation is 17 days. Limitation is 17 days. And another thing, the matter is extremely urgent. Advocate was suffering from infection of the legs for which he residence. "17 days delay, my lord."
It was dismissed. The appeal was dismissed on 15/1/20. Default clearance of the application has been filed for restoration. Along with the condemnation application, the service has been effected. Affidavit in this regard has also been filed. Going through the petition, we are satisfied that there is sufficient cause for restoration of the application is allowed and the appeal is restored to its original files and number.
Another thing, the matter is urgent in the sense, I have also mentioned the matter because
Dismiss and urgent. Sorry.
Police health order has been passed. Let the matter be placed under order 41. That's order 41. Order 41 and the next application for application must stay on.
First cross the hurdle of admission, thereafter this matter will be listed for admission.
In fact, I mentioned the matter for admission. Disputed brother and sister eviction of a licensee. Grateful.
28. 29.
$237. I'm paying not to different.
Why?
I have no stay application. Section 5 application, memo of appeal with me, stay.
Section 5 allowed or not?
No, no, no.
So have you served the copy?
Yes, yes. Yeah, আসুন, আপনি আসুন তো।
Give him a copy of condonation.
Condolation, I have.
Let the condonation
Yes.
application be taken up. Many days delay, state.
Item number 229, 254 days.
Yes, what is the ground?
Departmental communication and proposal for permission.
I'm talking about this FAT 716. 71. You have taken up this. 180. Says service. Where is the service?
आपने copy दी?
After doing the service, sir. Service has not been affected. There is no direction for service.
No, not it.
So you'll have to serve.
Yes, my lord. I
Service. Returnable 1 week after vacation. Yes.
229 to 237.
Have you got a copy? Yes. How? They have given. Call 30. 229. The same order of service.
237.
Here.
230, 268 days delay.
Now. Get called 31 thereafter thou. What 94,000 rupees you are charging saving an order. What the state is doing? Acquisition matter only. You have valued the appeal at 94,000 only.
Yes.
That means the compensation must have been 94,000. You are filing an appeal.
The department has asked, and
So we are condoning the delay upon a cost of rupees 1 lakh. Total. Note. We will impose a cost of rupees 1 lakh condonation, and then we will hear out the appeal. It's wonderful. appeal from 94th court and you are preferring appeal. And the LR has waited to prefer an appeal. We did not look at the application. Application is still lying here. We have seen the memorandum. From the memorandum, we find this is the value which he has given. Yes. That's why I'm asking. For even less than 1 lakh rupees, is there any policy decision of the state
I don't know. I have assigned from the department.
on a land acquisition? No appeal shall be preferred.
I also realized that it is so.
In the Income Tax Act, I find there are circulars which says that up to this amount, no appeal shall be preferred by this department. Similarly, here, 94,000. I can understand. No. How it is being started. Why it has been started. government has taken decision regarding this particular, I think, cases of the government, 90,000, 95,000. I think it's coming. You have the copy. Can you file your opposition? A short one. Within 2 days. For 3 days, can you file? On instruction, they don't want to file it out. On instruction, I am saying they want to. Then you are not opposing. They want orally will not do. They want the money and at least paper book they are also ready. Not realize the pulse of the range. Understand, mother. I verily understand. I verily understand. Not realize then what can be. Yes, I understand. I understand. I request it. It has to be understood. Which is the application. 168 days. Receiving the in enhancing the compensation to the respondents in relation to Act 1. Act 1. 6. Act 1 of 1894 or 6?
1894.
1894.
1894.
1894. Act 1. Stand the there is the meaning of 1. veracity of the length of the lead. The moment and submits that they have constitution. Sir, they are out of and when all these person they are out. Any application for stay? Yes. That application be listed on Monday. Monday application for stay. This can 8 matter. Can one? Can one is a stay? No, continuation.
Can 1 section 5.
Can 2.
Can 2
is
just
a stay. Yes, this can 2. But now all these 5 we will be taking up application in the first half and second half or like this. But 8 matters. All these matters, condonation is allowed up to that. Up to 37. And now you miss the bus. But did not realize. Yes, I understand, my. I understand, my. If you file a 2 days short affidavit, we could have imposed at least 50,000 rupees cost. Anyhow, because 259 over again, getting it from 230. They will want to file the paper out of court and to deposit this better than their cost. So that should also have covered up. Sorry, we are. You are saved by them. Yes, call the next. Continue. We'll sit up to 2. We can't travel. But we'll next. 232.
237.
No, this is all up to 237 all over. 38. Okay. $38. 39.
239, my lord, I beg to appear on behalf of the appellant petitioner, my lord. My lord.
I want you not to use that particular word big. Many a times.
My lord, I am appearing for the appellant petitioner, my lord. My lord, plaintiff is the appellant before your lordship, my lord, in a suit for partition. My lord, my claim in the partition suit is that, my lord, I am the 1/3 shareholder of the suit property, which is, my lord, application for injunction, appearing before your lordship. My lord, not to transfer, alienate, and create third-party interest by the respondents before your lordship.
Create, why can't they? Then what is the
My lord, kindly, if your lordship kindly passes a short order of status quo, my lord, so that they cannot, my lord, transfer or alienate the property.
Co-sharer has every right to transfer. Can you prevent any co-sharer from transferring his share? Only in respect of a dwelling house, or you have a right. But it is not a dwelling house.
My lord, a part of, my lord, there are landed properties and there are also, my lord, dwelling house, my lord, if I'm.
One may not be. It's a dwelling house means not a separate one building.
No, my lord.
Not a separate one. Because of section 44 of the
Transfer of Property Act.
I'm talking about.
And my lord, there are, and subject to correction, they can also transfer it. No, my lord, it's appearing for the first time.
Somebody has appeared, respondent number 1.
They are all brothers, my lord.
Ujjaini Das.
Ujjaini Das.
I do not know.
No.
Ms. Jaini Das. He has entered appearance for respondent number 1 and 2.
1 and 2.
And you are seeking injunction against them.
Yeah, my lord.
Serve the copy and then come back. Use it. Serve the copy.
Much obliged.
Put the record.
वकालत नामा क्या?
This the matter of. Yes, call the next 39. Just 239. 39
This is my matter, my lord. And where your lordship has passed the order, my lord.
40 minute I agree.
My appellant is the petition group. There are 3 applications, my lord, your lordship will find in the field.
Restoration has been allowed.
Can 2 has been allowed, my lord. Can number 1, 3, and 4. Can 1 is the stay of the stay has been prayed on behalf of the husband, my lord, alleged husband, what I should say, my lord, because a suit for restitution of matrimonial dispute between a before, my lord, I was humbly praying
42 ample the appellant petition. 42 my lord, from the appellant petitioner, my lord, my application, the appeal was admitted and there was a ad interim order of injunction.
FMAT.
No, my lord, the effect. FMAT.
And interim order was passed.
Interim order was passed. And my lord, so notice was served upon the respondent as per the direction. The respondent, Mr. Kollal Kumar Maiti and Mr. Tanmoy Mukherjee appearing before the lordship. Appearing. My lord,
Mr. Bose.
Mr. Bose.
Oh, Mr. Bose.
No, Mr. Bose. And my lord, the earlier respondent.
What? They are not appearing. What do you say?
My lord,
Over or what?
My lord, they fix the matter. My lord, the Friday.
Don't worry. Not today. It will. Next week it will come.
Next week, my
Yes,
Friday.
it will come. Yes, next.
Madam, for the petitioner item 43. Madam,
The
70. Yes, sir. My lord, my specific query is appellant petitioner filed a suit for partition, and along with an application under section 44 of the TP Act read with 151. And following that, appeal was preferred. Appeal has been admitted.
You will not get it.
Yes.
That application under section 40.
So that application was rejected in the trials court. Yes, that application was rejected. Yes, and that appeal has been admitted.
So that appeal.
No, my lord. Yes. Appeal has been admitted, and along with that,
Interim order has been passed.
yes, there was an injunction.
Not to interfere with the.
Yes, my lord. And in that application, only respondent number 6 contested, and prayer was made, my lord, to and in this application, I have made a prayer to dispense with the service.
From which order?
For this is an application for appropriate order, my lord.
This appeal originated from which order? That order rejecting section 44?
Yes.
This order was passed in this appeal.
Yes.
Say that.
Yes.
At least you should state the facts with clarity.
Yes.
Don't worry. Where is that order by which the injunction was done?
It's in, my lord, page. Page 10.
Order dated second.
Annexure A, my lord, page 10.
Now, what you want?
Yes, my lord, my prayer is that the service of notice of appeal upon the other respondents be dispensed with. And only respondent number 6 appeared and contested in the CAN 1.
The only respondent number?
Respondent number 6.
Appeared in the suit.
Yes, appeared and contested, and also in the CAN 1, he appeared. So my prayer is that the
primary relief is against the respondent.
Yes.
It's a stranger purchaser.
Yes, he's stranger purchase.
an application. Based on dispensation of service upon other respondents except the respondent number 6. You have filed a suit for partition.
Suit for partition and permanent
You know declaration what?
suit for partition.
You're the plaintiff.
Um,
The plaintiff has filed a suit for partition. An application during the pendency of suit alleging that one of the petitioner has transferred his share in favor of the respondent number 6. It's stranger to the family. He says that the suit property comprises of a dwelling house, and therefore the stranger purchaser is not entitled to joint possession in view of an embargo created under Section 44 of the Transfer of Property Act. The trial court refused to pass the order of injunction, which is assailed in the instant appeal, and an order of injunction is passed by the dividend bank, which stood affirmed subsequently. Since the respondent number 6 is the alleged stranger purchaser, we therefore find that he is the contesting respondent, and therefore there is no justification in declining to the prayer in the instant application that the service of notice upon the other respondents may be dispensed. Accordingly, the application is allowed except respondent number 6.
My lord, one more prayer, if I may. Yes, sir. Yes, the learned advocate for the respondent number 6 already appeared, and the paper book is already ready, my lord. So let the appeal be heard and disposed of fixing an early date. And paper book is served already.
Let the appeal be listed 1 week after the Oh.